Hey everyone, welcome to this video version of the appellate court. We're going to hear the matter of Cordero versus the Commissioner of Correction, AC docket numbers 44193. I'm Judge Bright. I'm sitting this morning with Judge Prescott and Judge Clark. This hearing is being conducted over the Teams platform, so everyone is appearing by video and the argument is being live streamed. I'm going to ask everyone to identify themselves for the record just to make sure we can hear and see each other okay. I'll start with the judges, then with the appellant, then counsel for the appellee. I'm Judge Bright.
I'm Judge Prescott.
Judge Clark.
Mr. Cordero, could you identify yourself, please?
So represented appellant Jose Cordero.
Assistant Attorney General Zenobia Graham Days, here on behalf of the respondent, the Commissioner of Correction.
I can see and hear everyone okay. I assume that's true for everyone else. If at any time you're unable to hear or see anyone, please let us know, and we'll take whatever break we need to make sure we're all on the call together. Each side will have 20 minutes to argue. The appellant can reserve some time for rebuttal. I will keep the time. I will hold up a sign when there are 2 minutes left, when there is 1 minute left, and then when the time is up. So with that, I think we're ready to proceed. Mr. Cordero, are you ready to go?
Yes, sir.
All right.
The Americans with Disabilities Act, ADA.
Mr. Cordero, how much time would you like to reserve for rebuttal?
The opening argument is brief. It might be like 5 minutes, and the rest for rebuttal, if it pleases the court.
Okay, go ahead.
Begin? Thank you. The Americans with Disabilities Act, ADA, is a well-settled statutory law enacted for the intent and purpose of protecting Americans with disabilities from disparate treatment pursuant to the 14th Amendment to the Constitution of the United States. Because the appellant is immunosuppressed, he is purviewed as a member of a suspect class pursuant to the ADA. As a result, the appellant is construed as a qualificant for any pre-existing liberties devolved by the ADA that are construed protected by the constitutional privileges and immunities devolved by the Constitution of the United States and the Constitution of the State of Connecticut. In the instant case, the liberty devolved by 42 USCS Section 12147 of the ADA statute. Section 12147 is construed as substantive documentary evidence with probative value pursuant to Rule 10C1 of the Connecticut Rules of Evidence, and can be introduced as evidence when examining an ADA expert witness doing cross-examination in a trial proceeding pursuant to the 6th Amendment to the Constitution of the United States. Because the aggregate elements of the ADA are construed as settled law, its aggregate elements are construed as substantive rights. Any limitation on 12147 during cross-examination of an ADA expert witness in a trial proceeding operates as a deprivation of the fundamental fairness protected by the Due Process Clause and therefore construed as reversible error. A claim that is squarely raised in prior litigation at a separate jurisdiction according to settled law, but that remains unlitigated, countervails the limitations prescribed by res judicata pursuant to the amplified analysis set forth in Pierce v. Commission of Correction. And that concludes the opening argument, Your Honor.
I'm sorry. You used 2 minutes, so you'll have up to 18 minutes for rebuttal if you need it.
Thank you.
Okay. Graham Days?
We know that the petitioner has already filed 4 actions leading up to this habeas petition. And for the first time, the petitioner was given an opportunity to litigate the merits of his claims. And instead of presenting exhibits or calling a witness, he relied solely on his own testimony. And the habeas court correctly determined that was insufficient to establish his burden. The petitioner failed to establish that he was subjected to deliberate indifference. There was testimony from Dr. Freston that made it clear that the petitioner not only was receiving medical treatment, but that his conditions were properly and adequately being addressed. We also know that when the petitioner raised this ADA issue, he did not satisfy the legal requirements. We
Hold on
can't
one
even.
second. Attorney Graham Davis, hold on 1 second. I think Mr. Cordero, can you hear her okay?
Off and on. I can't hear you now. I cannot hear you now.
Well, I'm not talking at the moment. Can you hear me now?
Yes, now I can.
Okay, all right. So Attorney Graham Davis, I'm going to ask you if you could keep your voice up as much as possible.
I will raise my voice and I will also raise the volume. Is this better, Mr. Cordero?
No, it was going off and on, the sound. I could hear you clearly, but it was going, like right now, I can't hear you.
Well, I wasn't talking just now, but can you hear me now?
Yes, I can hear you now.
Okay, I have no way of knowing when you can and cannot hear me. Do you mind just raising your hand if you have trouble?
That's why I was pointing at my ears. So I raised my hand.
Yeah.
Thank you.
Here, the petitioner is attempting to pursue an ADA claim in the habeas court, and it is our position that that is not the proper forum. Not only is it not the proper forum, because he failed to satisfy the Eighth Amendment claim, he is barred from raising an ADA claim in the habeas court. Mr. Cordero attempted to claim that he was subjected to an equal protection violation, but when questioned by the court, he made it clear that he could not identify another inmate. He could not determine why another inmate received single cell status. He also did not know any of these individuals' medical conditions. When we look at this record, it is very clear that the petitioner has not satisfied his legal burden. We also know that when he made this claim about his due process rights being infringed upon, he overlooked the fact that he did not avail himself of the internal procedures that are made available by the Department of Correction. There was testimony from Director Gallagher that the petitioner never appealed the ADA rejection. When we are considering the ADA claim, we also know that the petitioner did not establish that single cell status is a reasonable accommodation. The petitioner also did not present any evidence that he was denied or deprived of any programs, services, or treatments. It is our position that an ADA claim should not be presented in the habeas court. But even if this court were the proper forum, the petitioner has not satisfied his legal burden. The habeas court correctly limited the testimony of Director Gallagher. That testimony was limited to the information that was elicited on direct. Because the petitioner was pro se, he was given some leeway. However, we cannot overlook the fact that the petitioner could have, but failed to identify and call his own witnesses. The petitioner could have and failed to provide the court with a single exhibit. The petitioner received an opportunity to be heard. And when given that opportunity, he took no steps to actually satisfying the legal burden. And if there are no further questions, I would like to just rely on my brief. Thank you.
I see no questions. So, Mr. Cordero, you will have 18 minutes if you need it.
May I proceed?
Yes, proceed.
Thank you. Issues of fact. The Department of Correction, DOC, is a public entity pursuant to 42 U.S.C.S. Section 12131 of the ADA statute. The appellant is immunosuppressed by the human immunodeficiency virus, HIV, which is construed as a compromised immune system, pursuant to 42 U.S.C.S. 12902 and 12909 of the ADA statute. Single bunk social distancing altered existing facilities at the Cheshire Correctional Institution, CCI, are construed as conditions of confinement for confining an infectious individual pursuant to 42 U.S.C.S. 12147 of the ADA statute. The Eighth Amendment applies to conditions of confinement. Consequently, denying the immunosuppressed appellant any element involved by Section 12147 during a viral pandemic is construed as cruel and unusual and therefore an excessive sanction. See Helen v. McKinney, 113 Supreme Court of the United States, 2475, 1993. Depriving the appellant any pre-existing right devolved to individuals purviewed as a protected class under the ADA subjects the appellant to the type of disparate treatment prohibited by the Equal Protection Clause of the 14th Amendment to the federal Constitution as applied to the states. No person shall be denied the equal protection of the laws because of physical disability. Amendment 21 to the Constitution of the State of Connecticut. The ADA does not require exhaustion of administrative remedies prior to litigation with the courts. See Gorsline v. Kansas by and through Secretary of the Department of Social Rehabilitation Services, 1994, D.C., Kansas, 5 ADD 343. The trial court limited the appellant from presenting substantive documentary evidence as burden of proof for the purpose of articulation by the state's ADA expert witness during cross-examination in violation of the Sixth Amendment to the federal Constitution and Rule 10C1 Connecticut Rules of Evidence. Questions presented. Do the appellees operating as a public entity have the power to deprive a qualified individual with a disability any pre-existing liberty devolved by settled statutory ADA laws and state ADA policies that are contemporaneously protected by the Due Process Clause of both the federal and state constitutions? Did the appellees impose an excessive sanction on the appellant who is immunosuppressed during a viral pandemic by denying the appellant a federally protected liberty construed as a social distancing condition of confinement pursuant to 42 U.S.C.S. 12147 of the ADA and Helen v. McKinney without due process of law? Do the appellees have the legal power to compel the appellant to exhaust administrative remedies that are not prerequisited by the ADA before filing litigation with the courts? Is the trial court's limitation on the appellant's cross-examination, where the appellant asked the state's expert witness, ADA coordinator Colleen Gallagher, to articulate the intent and purpose of the plain language of the substantive documentary evidence, Section 12147 of the ADA, of which the witness was qualified as an expert and which the appellant relied upon to meet his burden of proof, reversible error pursuant to the fundamental conceptions of abuse of discretion, e.g. debatable. Now, as a matter of evidentiary law, trial testimony given by the state expert witness, Dr. Freston, see trial transcripts, page 85, lines 15 through 18, where the appellant's exception was taken to the state's objection as probative to 42 U.S.C.S. 12147 of the ADA, implies that the altered facilities located in the North Blocks 1 through 6 at CCI were, in fact, altered to construct single-bunk social distancing altered existing facilities to accommodate a qualified individual with a disability who is infectious. For example, the altered portions of the facility are readily accessible to and usable by individuals with disabilities, 42 U.S.C.S. 12147, and at the time the building permit is issued, shall suffice to satisfy the requirement that facilities be readily accessible to and usable by persons with disabilities, 42 U.S.C.S. 12150. The ADA is an established statutory law constructed of legal rights that are granted to a particular group of persons, and every element that constructs and are devolved by the well-settled statute are construed as protected privileges immune from abridgment by any state pursuant to the Due Process Clause of the 14th Amendment to the federal Constitution. Therefore, the trial court's limitation on the introduction of 42 U.S.C.S. 12147 resulted in an unreasonable determination of the facts of the case and clearly established federal and state ADA laws. In Smith v. Wade, the Supreme Court of the United States articulates that a jury may be permitted to assess punitive damages in an action under Section 1983 when the defendant's conduct is shown to be motivated by evil, motive, or intent, or when it involves reckless disregard or callous indifference to the federally protected rights of others. the Supreme Court of the state of Connecticut has declared to qualify as a constitutionally protected liberty, the interest must be one that is assured either by statute, judicial decree, or regulation. Perez v. Commissioner of Correction. The appellate court of the state of Connecticut has averred there are two elements that must be established in order to find a due process violation. First, the plaintiff must establish that he has a liberty interest that comes within the ambit of the 14th Amendment. Second, what procedural protections are due. Jan G. v. Scott Semple et al. First, the ambit from which the appellant's liberty interest is established is 42 U.S.C.S. Section 12101B4 of the ADA statute, which states it is the purpose of this act to invoke the sweep of congressional authority, including the power to enforce the 14th Amendment and to regulate commerce in order to address the major areas of discrimination faced day to day by people with disabilities. Second, as to procedural protections that are due, the privilege and immunity which assures that an American with a disability is not deprived of any liberty interest devolved by the ADA without due process of law, caused by the abridgment of any law by any state which shall require the invocation of the 14th Amendment. The legislature of the state of Connecticut has enacted General Statutes of Connecticut, Section 52-4662, which states an application for a writ of habeas corpus claiming deprivation of liberty shall be made to the Superior Court for the Judicial District of Tallinn. Therefore, because the substantive words written into the Americans with Disabilities Act are, in law and fact, liberties, the liberties construct a privileged statutory relationship between a qualified individual with a disability covered by the ADA and a public entity. Moreover, because the substantive context of Section 12147 of the ADA are the basis of the appellant's case in chief, any ADA expert presented on behalf of the state can be subjected to unrestricted cross-examination on the ADA during a trial proceeding to show burden of proof of the appellant. Burden of proof on behalf of the appellant. The state briefed the alternative ground of res judicata to be applied to this docket due to a prior complaint filed under 42 USCS Section 1983 by the appellant in the Federal District Court of Connecticut pertaining to the appellant's physical condition, HIV. However, the district court disregarded medical documentary evidence that was regarded by the trial court for this docket submitted on behalf of the appellant as an addendum to his complaint. Probative evidence corroborating that the appellant's physiological condition, HIV, in law and fact, falls within the purview of the disabilities covered by the ADA statute. The district court did not afford the appellant an evidentiary hearing to litigate a claim pursuant to well-settled ADA statutory laws. See Harris v. Commissioner of Correction, 108 Connecticut Appellate 209. As a result, the district court's not providing an evidentiary hearing to litigate the appellant's probative burden of proof as to his ADA qualified condition was never litigated on the merits, therefore does not qualify as a time-barred claim pursuant to res judicata as briefed by the state. See Pierce v. Commission of Correction, quoted in Brewer v. Commission of Correction, 162 Connecticut Appellate 8, and Johnson versus Commission of Correction, 285 Connecticut 556 and 566. More importantly, because of the current pandemic, the principles of res judicata can be legally contrasted with a new rule of law or newly discovered evidence that are construed analogously with the elements constructed in United States v. Garlick, which implies that COVID-19 poses an extreme exigency for individuals most vulnerable to harm from the virus. The appellant is one of the approximately 7 million fully vaccinated Americans with a compromised immune system, inclusive a booster shot, who is particularly vulnerable to the coronavirus. The cause of the coronavirus has been implicated by New York Times science writer Nicholas Wade as being subject to two main theories. One is that it jumped naturally from wildlife to people, i.e. zoonotic. The other is that the virus was understudied in a lab from which it escaped. The most ominous theory being the one implicating an in vitro genomic sequence that increases its built-in capacity to adapt and evade the veneer of protection stimulated through vaccination, a capacity that has already contributed to the death of thousands of fully vaccinated citizens of the United States. The particular capacity is phrased gain, G-A-I-N, of function. The gain of function is construed to be resistant mutation caused by the synthetically sequenced DNA base pairs of COVID-19, which is a capacity that instructs the coronavirus to change and adapt in order to facilitate and refacilitate an attack on the T cells of medically vulnerable immunosuppressed citizens of the United States. Consequently, because the appellant is pre-infected with the human immunodeficiency virus, his already compromised T cells are further compromised by the additional capacities of COVID-19, such as a quintupled infectious rate, which forms the sufficient basis to qualify the appellant for a pre-existing single bunk social distancing altered existing facility prescribed and devolved to qualify individuals with disabilities pursuant to 42 USCS 12147 of the ADA statute. The Connecticut Practice Book, Section 70-1C, authorizes the use of video conferencing for particular adjudications. However, its use for trial proceedings can be construed as a novelty issue, therefore construed as a question of first impression and subject to judicial review. CF Reed v. Ross 468 U.S. 1 and 16, on the basis of the litigant's inability to present intrinsic evidence to the court and witnesses for examination, which consequently conduces to infringement into rules of evidence, particularly to burden of proof or reliability and the examination clause of the Sixth Amendment to the Constitution of the United States. In brief, the appellant is asking this court to vacate the trial court's decision or to order a new trial allowing an aggregate examination and articulation of 42 USCS section 12147 of the Americans with Disabilities Act to argue the merits of the unlitigated claim disregarded by the district court, inclusive the ADA statute's applicability to the appellant's issues and claims of law and facts briefed for his appeal, or in the alternative, for the court to find reversible error in the trial court's limitation on the introduction of the appellant's substantive documentary evidence supporting his case in chief, i.e. 12147, which he attempted to introduce to the trial court during cross-examination of the state's expert witness. Thank you. I have a few words too I would like to add to one of her statements, if it pleases the court.
Go ahead.
The part about where I wasn't prepared, I didn't bring anything. When they called me for trial, that was the first call. They didn't notify me anything, and I came to trial with what I had with the two expert witnesses, and that's it. I didn't have an opportunity to subpoena, to gather evidence as to who distributes this and where are these cells located and who are these people that are accommodating these cells. I wasn't given that opportunity. It was almost like an ambuscade. Not to disrespect the court, but that's what it felt like. I just came by myself with what I had, my argument, that was it.
Did you ask for a continuance?
No, I was ready to go.
Okay.
But
All right. Thank you both. We will take the matter under advisement. We will stand in recess while we go to the courtroom for our remaining cases. Have a good day.
Thank you. Have a good day.
Take it easy.